All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
You may be seated. We thank everyone for being here this morning. Chief Justice Parker and Justice Sarah Stewart could not be with us today, but as always, they will have access to the video of this recording and will review it. So we'll just go ahead and get started. I'll ask the clerk to please call the docket.
In case number SC 2022-0981, ex parte Dr. Lisa N. Herring and Dr. John C. Lyons, Jr. Arguing for the petitioners, the Honorable Mark Boardman, and arguing for the respondent, the Honorable Forrest Latta.
Mr. Boardman, you may approach and begin.
May it please the court, together with Kate Watkins, Carl Johnson, Africa Parchman, and Claire Puckett, we represent the petitioners, the retired now superintendent of the Birmingham City Schools, Lisa Herring, and the remaining principal at Huffman High School, Dr. John Lyons. We ask that you grant this petition for writ of mandamus for three reasons. First, state agent immunity protects Dr. Herring and Dr. Lyons because they did not violate any specific rule, policy, procedure, or checklist which directed them to take some certain action. Second, state agent immunity protects all educators in this sense from any claims of negligence, and that's at best what the plaintiff can offer. And third, that good public policy requires broad state agent immunity, because in this crisis we have in current education, for example, trying to hire qualified people to teach our students and to make Alabama a better place, unless we give protection to them, these educators will take other jobs that pay them more money and do not help society. State agent immunity protects Dr. Herring and Dr. Lyons from this tragedy because they didn't do something that the plaintiff or the plaintiff's expert says they should have done to have prevented this incident. All they acted on was discretionary function, immunity issues, decisions that they made in order to proceed as running the school at Huffman High School and, of course, the entire system. This state agent immunity does not rest only on Article 1, Section 14, but as Justice Mitchell pointed out in the Pinker decision where y'all reversed Barnhart, and Barnhart doesn't have anything to do with this defense, the state agent immunity is also statutorily created. In 2014, the legislature passed a statute. And that's important because in states other than Alabama, educators don't get sued. The school district gets sued, but here our Board of Educations are immune. Alabama, unfortunately, therefore, leads the nation in lawsuits against educators. And if you think about that, because when they want to make some type of claim, an injured student or a parent makes a claim against the Board of Education. That's why good public policy requires broad state agent immunity, because if we don't protect those individuals, then they're not going to do the job that we want them to do. As this court wrote in Nance versus Matthews, further, we recognize that without some degree of immunity for the performance of these education functions, public officers and employees who perform them may act not on the basis of policy, but with the goal of avoiding personal liability or vexatious suits. Now here, the plaintiff nor the plaintiff's expert tell us exactly what Dr. Herring or Dr. Lyons should have done. There is no specific instruction, do this, do this, do this, do this. But I can tell you, and you can imagine too, a way to avoid an incident like this. First, let me give you the facts. We had Miss Arrington was a senior on March 7, 2018, when tragedy struck. Mr. Barber was a star football player, perhaps the best football player on the team, had just finished a trip to visit Dabo Swinney at Clemson to be recruited to play football there. Not a discipline problem. The only problems on his record, tardy. He had gotten a gun, not because he thought he needed protection at Huffman High School, not because he thought he faced some threat at Huffman High School, but because he needed protection from the outside, something happening outside. And the ills of society will come into the schools, and that's what happened here. He didn't have the gun with him when he came into school that day. There are 41 doors to the entrance that enter into Huffman High School. None of them are alarmed. They are now, but they weren't then, because that's not a decision to be made by Dr. Lyons or Dr. Herring. That's a decision to be made by the Board of Education, because neither the principal nor the superintendent of the schools can either hire or fire individuals or, for that matter, spend money. The Board of Education is responsible for doing that, and the Board of Education is the entity that they're really aiming at when they make a claim like this. I mean, when it comes down to the way the claim actually sorts out, you look at well, Justice Mandam, you said in one of the cases, the ex parte, your special concurrence in ex parte Blunt, where Coach Kine's daughter was killed in that accident in Tuscaloosa, where the kid went to go to McDonald's. You said that this. Actually, I'm sorry. You said that they're an agent of the state. They're not. These students are not agents. They're not agents that we can control. They're independent people. And what this independent person did was he went to get his gun, which he had given to his friend, and his friend was leaving school in the middle of the day. Now, they snuck out. The argument is that Mr. Lyons is somehow responsible for students skipping school. Oh, come on, that's been a problem for all ages. That's not something that the superintendent has a responsibility to actually be responsible for. And the fact that they snuck back in through a door, the same door they exited. He went out during lunch, got his gun out of his friend's car, because his friend said he was leaving and he didn't want to keep the gun in the car. The student had nothing better to do with the gun. He stuck it in the waistband of his shorts and he went back into the school. How did he get back into the school? He did not go through the main door because he knew there were metal detectors there. He went back through a doorway that was locked from the outside, and in order to get access, he had to call a friend to open the door from the outside. Now, the argument is that there were cell phones being used at school, and that's somehow the responsibility of the principal and the superintendent. No, there's no evidence that these rules were not enforced. There's no evidence that before you other than the specific violations, and what that means is the students got away with skipping school to go get the gun and getting back into using a cell phone. And for that matter, maybe perhaps not going to the proper classes. But again, that's not the responsibility of Dr. Lyons, who has over 1,300 students at that school, and it's certainly not the responsibility of Dr. Herring, who has multiple campuses throughout Birmingham. Neither of them can enforce the Code of Student Conduct. They have to have teachers who report matters to them, and remember, there are no teachers sued in this case. It's only the principal and the superintendent. So we get back to the claims that the plaintiffs make. They give you some policies that they say were supposedly violated, but a close look at those policies demonstrates that every one of them is a discretionary function. For example...
Before we get there, would you, if the principal had actual knowledge of the violation of the Code of Conduct, if he knew that this student was making cell phone calls or that this other student had brought the gun into the school, actual knowledge by the principal, would you agree with me then that it would be a violation of a checklist type of policy and that we would need to allow this case to move forward?
No, Your Honor, I wouldn't, and here's why. First, that's not in the evidence. There's absolutely no knowledge that anybody knew he had the gun. But the second part is this. That is the discretion that an educator has to enforce. Just as a police officer who perhaps would have wanted to pull me over did not issue me a ticket, just because he failed to do so, or just because the principal failed to actually make a specific ruling and discipline a student for that, that's the ultimate in discretion. You have to decide in educating students what's the best way to do those things.
Now, we do have the Code of Conduct case that they've cited. It's the Yancey case. Am I saying that right?
You're right. Yes, sir.
In that case, the teacher, the coach, they allowed that case to move forward because the coach had told them to use their vehicle to move the trash, if I remember right. So there was complicity there between the teacher and the students violating the code. Here, if the principal had actual knowledge of the gun, would you say that's enough to say that the teacher, the principal here is complicit in the violation of the Code of Conduct?
Potentially at that point, because then you're talking either some type of conspiracy or some type of more active negligence. Here you've got a passive negligence because they're sued as captain of the ship. Let me address the Yancey case because I know it well. It was mine. This is my 54th case representing educators before y'all, my first time for oral argument, so I'm happy to be here. In the Yancey case, the Code of Student Conduct says you may not go to your car during the day. And there's actual testimony from the students there that the coach not only saw them using it, but told them pull the tailgate up and give them instructions to it. So he facilitated the violation of the code. And it was because of that violation that happened. So perhaps in a situation like this, if someone knew of the gun, either the ROTC colonel who was in the hallway who stopped the assailant, the one who was convicted of criminally negligent homicide from going down to the arm, it'd be different if that creates some type of environment where this happens when you tell the student, go get in your truck. And that was, look, high school kids, I'm about to run out of time, high school kids will do strange things. So, but I want to point out that what we're dealing with...
We have the affidavit here, right, of Ms. Tolliver, is that right?
Right.
And that's what they're trying to establish for that affidavit is the principal would have knowledge of this violation of the code of conduct, would have knowledge of the gun. I'm not saying that establishes it in my mind. I'm just saying that's certainly what the plaintiffs are trying to argue, right?
Could be
But
five particular things.
Let's just assume we granted those inferences and said, okay, it got to the office, it must have gotten to the principal. If he knew for sure there was a gun in the hands of somebody in the school, now the affidavit didn't say who, but somebody in the school, can we then get to the point of saying, well, there's a violation of the code of conduct and the principal's aware of the violation of the code of conduct, he doesn't do anything?
5 points with regard to that. First, there's no evidence that there's no evidence that Mr. Lyons knew. In fact, the affiant who says that she didn't know if the lady she talked to even heard her, and then she said, well, she thought the lady would tell Dr. Lyons. Dr. Lyons testified he knew nothing about it. Second, that's not even properly before the court because it was post-hearing that it was submitted. Third, incredibly, she saw somebody with a gun, yet she let her own student go into the school. Fourth, Dr. Barber did not go into the school that morning. The testimony is very clear. He went in at lunch. And finally, Cason versus Oliver, a case that was a wrongful death case decided by this court where you said that you will not, and that's where a kid died at school, and presumably it was because someone had locked a gate, either unlocked or did not lock it in a closed position, and the student was shish kebabbed by the gate when the car he was riding in ran into, and y'all said, just because one of the principals had one of the 4 keys doesn't mean you can support an inference that he is somehow liable. Fastest 10 minutes of my
Thank you, Mr. Boardman.
Thank you.
Mr. Latta, you may approach and present your argument, please.
Thank you, Justice Shaw, and may it please the court. Petitioners ask, where's the checklist? I counted the word checklist 25 times in their 2 briefs, like it has some type of magic spell. But this is not a typical checklist case. These were 2 top school system employees who were given a direct mandate by a public board of education to develop and implement a safety plan, and they did nothing to carry it out. They just blew it off. If you want to refer to the term checklist, they were given a checklist and it had 1 item on it, and that is to go and develop and implement a safety plan. Cranman, as its opinion illustrates from the result, is not a free pass. It does not afford discretion to ignore a Board of Education mandate to create a safety plan, nor is a literal checklist the only way to prove beyond authority. It's just one of the ways. You've heard the facts. Courtlin Arrington, a high school senior, 3 months from graduation, gunned down on campus by a fellow student with a 9mm pistol. Petitioners are not entitled to immunity for 2 reasons. First, they cannot point to any safety plan they developed and implemented as they were required to do. I would just ask your honors to please look at the depositions. They're short, of Principal Lyons and Superintendent Herring. Their own testimony indicates that they did nothing to carry out the board mandate. By their own admission, they were not aware of the board policies regarding safety. They've admitted it in their depositions. So they were not performing an immune function, and they therefore should not be entitled to claim immunity. Also, safety is a different function from education. If schools are not safe, parents will not support them, and no education will occur. Second, even if the petitioners could prove that they were performing an immune function, which they were not, the judge rightly found that there were issues of fact that exist, viewing the evidence in a light most favorable to the non-movement, that petitioners were acting beyond their authority by failing to carry out their instructions to develop and implement a safety plan, and specifically for Huffman High School. It's almost unbelievable the amount of evidence of their failure to have any kind of safety plan. Here are 7 quick things in the record that you'll find. 1, expert testimony from the consultant in Sandy Hook and Parkland, who in those cases was working on behalf of the school board, who testified by affidavit and in his deposition that petitioners failed to develop any safety plan as required by board policies. Their only criticism of this expert's testimony is that he didn't point out any specifics. Well, there are no specifics because they didn't do anything. They just utterly failed to implement any kind of plan. Number 2, actual notice from an eyewitness who saw the shooter go into the school with a gun 3 hours before the shooting and promptly called the principal's office, which did nothing. 3, a history of gun-related activity in and around this school monthly, if not weekly, in the run-up to this shooting. 4, no safety plan, no safety committee, no safety training, and no restricted access. All of this comes through in the deposition of Principal Lyons. 5, no use of metal detectors, which were not even plugged in. And they had security cameras, but the only screen was in the principal's personal office, and no one was monitoring it. 6, a total failure to track and report school-related violence as required by board policies and by the Alabama Code. And 7, 2 affidavits, one from a former board member and another from the system's recent safety director.
Weren't those struck by the trial court?
They were not considered by the trial court because they didn't have the magic language of having personal knowledge, but it was evident from the affidavit that the board member had personal knowledge of the enactment of the board policies and that the safety director had personal knowledge of what he said were plans that they had at one time, but nothing was in force at the time, and it was mandatory and non-discretionary, so they had no choice.
Just so I understand your position, it's your position that there were no safety practices implemented by the principal?
That's correct. That's correct. There was no plan. It's supposed to be an evidence-based plan containing specific practices. That means a school by school, because all schools are different.
So, Mr. Lytle, I'm sorry. I just want to interrupt you on this safety plan that they, in their failures. Are those failures, do those rise to something that's wanton? I mean, aren't they negligent? I mean, how do they get to the level of being wanton or malicious or something that was intentional, just that they failed to do it? I'm trying to get beyond just mere negligence for the things that you've mentioned.
Well, if they're acting beyond their authority, then they are subject to negligence or wantonness under a wrongful death claim, and that's what this is a wrongful death action. And to the extent that they're acting beyond their authority, then they're subject to liability in their personal capacity as anyone else would. And it would be the burden of the plaintiff to prove either negligence or wantonness under the Wrongful Death Act, and in the case of their utter failure, I mean,
But from an immunity standpoint, don't we have to get beyond negligence?
The court has to look at whether the action was outside or beyond their authority. If they were acting within their authority, they can be negligent and not liable. And so there would be no liability for negligence if it's performing an immune function. But if they're not performing an immune function, then they're functioning solely in their individual capacity. It would be no different from any other citizen who was negligent or wanton, and they would be subject to liability because now they're not protected by the shield of their public office.
But they're educators, right?
They are
Both of them.
educators.
And so that the burden, once they get that they're educators, then the burden shifts to you to show one of the exceptions.
That's right, and you know, that wasn't really an issue that the trial court considered, but I'm coming into this with fresh eyes, and I see a question here about whether there was even, there's an antecedent question of whether they were even performing a state function, because to be performing an
wasn't
immune
argued,
function, sir?
That wasn't argued by.
It was not, but it would be part of the plaintiff's case. And let me just say, they said it's been conceded. In their brief, they used the word conceded, and nothing like that's been conceded, and it would still be something that the plaintiff would be allowed to prove in their case in chief in the trial court. I just don't want that to be waived when we get back to the trial court.
Mr. Latta, let me ask you, as I understood your argument walking in this morning, it was that the petitioners have done little to nothing to develop and implement evidence-based policies to prevent violence. But as I sit here and listen to you in argument this morning, you're basically taking an even harder position, which is they've done nothing. Am I understanding your argument correctly?
They can't point to a single thing they did in response to the board policy.
So when Mr. Boardman comes back up, if I end up asking him to refute what you've said there, which is emphatic and unequivocal by you, and he's able to point to something, I mean, if the petitioners had done little as opposed to nothing, would that satisfy the alleged requirement under 625.7 of the policy manual?
No, Your Honor, because of the fact that they were assigned to create a plan. It would, in my mind, include a threat assessment. They don't even know what the word threat assessment means. They were not even willing to acknowledge that there is a board policy on safety. It's so far from their mind that nothing they did would have been pursuant to a plan because they had no plan. Justice Mitchell, in fact, you would think, when you look at this record, that on summary judgment...
Mr. Latta, doesn't all this go back to that it seems like our case law talks about that it must be detailed rules and regulations, not broad statements of policy like, you know, let's get away from this case, but say a jail circumstance, you know, prisoners need to be taken care of humanely. That's just a broad statement. It's not a detailed policy.
They criticize our argument on the basis that this policy was too broad to be implemented. But a mandate such as this by a public board of education is by its nature going to have some breadth to it. It could hardly be more clear. And
don't you agree but our case law does talk about detailed policies. So for instance, say the board had said the principal shall ensure that all doors are locked between 8:30 and 2 o'clock except the main entrance. It would be a detailed regulation that seems to be missing. It seems to be a broad...
Your cases have two general contexts, as I see it. One involve frontline employees who really don't have a lot of discretion in how they're to carry out their work and should not be subject to criticism and liability unless there's some clear-cut guideline. But the other set of cases involve executive-level policies that have been given, in this case, to the superintendent and to the principal, which...
Fairness, I'll follow up on that point, but it actually says each Birmingham City school shall do all of the following. It doesn't state the superintendent, the principal, the assistant principal,
You have to read that along with the further board policies and definitions of what their roles are. First, let me just mention that in both of their depositions, they admitted that it is their responsibility to carry out the board policies assigned to each school. Principal Lyons at page 55, Superintendent Herring at page 32, They're required to enforce the Code of Student Conduct and all other policies mandated by the Birmingham City Schools Board of Education. That's part of their job duty, and they acknowledge it.
But, well, let me take an extreme in this discussion that we're having. You say there was no policy at all. Well, let's assume for a moment, instead of this tragic event happening, two kids at football practice get into a fight, and one of them breaks their arm. There's no safety policy in place. The superintendent and the principal would still be liable.
So that's the danger of a case like this is coming before you, is that they're inviting you to enter in, to issue an opinion that's going to basically say that it's optional whether a school leader is obligated to follow a board mandate to develop a safety plan.
But
now, what that
you
safety
would agree
plan
under
would
my
look like...
example, though, that I just gave, that a plaintiff could withstand summary judgment on immunity.
Well, you have a couple of cases like that. The wrestling coach, you have the case, the Jamboni case involving the wrestling coach where a boy was hurt in the middle of one of the wrestling exercises.
Again, if there's no policy at all, every incident of any sort of violence, ever how serious or minor, ever how many high schools or schools there are, period, in Birmingham. I mean, two kids at an elementary school get into a fight on the playground, and before the teacher can break it up, one of them gets injured. There's no policy in place, so therefore the superintendent and the principal would be responsible.
Well, I can only say that in response to that, the principal's job duties as assigned are to define the responsibilities and accountabilities of staff members. In other words, Principal Lyons is the person who's supposed to create the checklist, okay, to give to teachers. And without a checklist, they won't be able to be...
Respectfully, it says each Birmingham City school, the board was not even sufficiently clear as to what official within a school is supposed to do it.
Well, when they say that each school, that is a direction to the chief executive of the school system, which would be the superintendent. This is by her testimony, Justice Mendham, and the CEO of Huffman High School, and he says it's his responsibility as well to implement board policies. And here I understand the hypothetical, but here we're talking about an express instruction given to, it would be equivalent to a college president or a department director or someone at the executive level from a public oversight board, which is not an expert, but they're saying we want you to go develop an expert plan and implement it based on evidence for each school. And they just totally fail to do it. And to get back to a question earlier about what evidence they could cite, one of the glaring omissions in this case, in response to the motion for summary judgment, you would think that they would have cited all the things that they actively did do and were involved in. It's similar to a case that Justice Bryant had called Price, I believe, involving a prison warden, where that defendant was able to show all of the things they did to try to preserve safety in the prison involving alleged defective locks, door locks within the prison. And you contrasted that case with one earlier that had been called Brown, I think it was, in which there had been an affidavit that was just purely conclusory. So here what you have, let's compare it. They don't cite any of the things that they actively did to promote safety at Huffman High School. Not one thing. If you look at their own affidavits, which are just conclusory affidavits, citing their own discretion, but not citing any specific things that they did. If you look at their deposition testimony where they're asked, well, tell us the things that you did do to try to make the school property safely, they don't cite anything. So all they do is claim that, well, we weren't given a checklist and therefore we had no further duty, and therefore we can't be liable if we weren't given a checklist. But again, it was their responsibility to create the checklist. Or to put it another way, as I said earlier, they had a checklist and it had one item on it, and they did not do it.
Then is failure to do these things, you're saying they acted outside the scope, which gets us out of this. So failing to do these things, that is outside the scope of their authority, where if they have done these, that would be with inside. So it's that failure that we should focus on.
It's that failure to even carry out the mandate of the Board of Education to create and implement a safety plan. Now, in the process of developing that plan and implementing that plan, there would have been some discretionary authority, but we don't even get to that point because they didn't even carry it out. Let me go back to Cranman, and each of you has written, read, and studied Cranman, and you recognize its twin goals of trying to balance Section 13's right to remedy under the Constitution and Section 14's immunity under the Constitution. And there has to be a balance between those two, and that's what Cranman was trying to achieve. And so when you read Cranman, there's really no way to read it to say that a school official would be immune from suit for failing to carry out a direct assignment. When they just utterly fail to carry out the assignment, they would not be entitled to any type of immunity, especially, I would submit, when it comes to safety. The Alabama legislature has declared that safety is the top priority for schools, and let me just read you this statement from the legislature. It is the finding of the Alabama legislature that the people of Alabama have two basic expectations of their public schools. One, that students be allowed to learn in a safe classroom. And two, that students learn at the level of their capabilities. That's Alabama Code 16-28A-1 in the title on education. And so what they've done is they have separated and prioritized the two functions of safety and education. They want to rely on the function of education, but what they're ignoring is the function of safety, which they totally fail to do. My time is running short, but let me just to return to Cranman for just.
Can I ask you one question?
Yes.
I'm going back to something that Justice Sellers asked, and that was the failure to act. With regard to immunity, is it your position that the failure to act went beyond negligence and was able to rise to the level of wantonness?
Yes, I mean it's got to be, there's got to be a willful aspect to a refusal to follow an instruction that's been given to them by the Board of Education. So it would be greater even than wantonness. The word bad faith is used, and people don't often think about bad faith in association with these cases, but it is one of the exceptions and one of the ways in which the employee can be proven to have acted beyond authority. And bad faith is nothing more than an unlawful refusal, an unreasonable refusal to perform a duty. Many of you have had experience with the term bad faith in the insurance context, where there's an alleged irrational, unreasonable refusal to perform an obligation. Here, they have been given an obligation, they have a duty, they refuse to do it. My time is up. Let me just say in closing, Your Honor, our greatest fear is that there would be an opinion that would come out of this case that would suggest that safety is optional and that school leaders have the option whether or not, in other words, they have the choice whether or not they want to follow a public Board of Education's mandate to implement a safety plan for the schools. And on behalf of the family, we would just ask that Your Honors deny the petition for writ of mandamus, as they've not met their burden of proving a clear legal right. Thank you.
Thank you, Mr. Latta. Mr. Boardman?
May it please the court. In the two-step process you've established for state agent immunity, the first step is to prove that there's a state agent performing a state function. They conceded at the trial court. That's impossible it's improper, therefore, to bring it up here and say that's not an issue, but that is suddenly an issue, but let me address it.
I think counsel said they never conceded anything.
The order specifically says that, but let me address it. As long as they are acting as the principal and the superintendent, that's all we have to prove. Then the burden shifts to them to establish something beyond authority or willfulness, whatever. Their burden can't be met because here are the 7 things that were done. First, there were SROs on campus. That was the process that Dr. Lyons had and Dr. Herring had. Second, there were metal detectors. They'd been in that building since they were built in 2011.
The metal detectors unplugged?
Metal detectors work whether plugged or unplugged. Metal detectors do not have to, because that's how they can take them out to the wherever they have to go, like the football stadium or something like that. So it doesn't matter whether they're battery operated. They were in use every day. And if nothing else, they are deterrent. In fact, they're deterrent because that's why Barber didn't come in with his gun through that door.
So they were functional.
They were functional, yes, Your Honor. There were wands so they could wand people if they were in the hallway. There were security cameras. And yes, the Board of Education only put the monitors at the school in Dr. Lyons' office, but the school, the Birmingham Board of Education, has a security department of its own that can see those things. But that's a decision made by the Board of Education and the money it wants to spend. Third, there were fifth, there were doors that locked from the outside. They all locked from the outside. They couldn't get an entrance into it unless, now they're alarmed because they got a grant to be able to fund that. They didn't have the money. Again, Mr. Lyons doesn't have the authority to do those things. Dr. Herring doesn't. That's the Board of Education when it comes to spending the money. And finally, they also, as Mr. Lyons said, he implemented prevention and intervention strategies. In fact, the last one of it, in his affidavit, he said, in addition to that, I assigned teachers and staff to monitor various areas inside and outside of the school building during and after school, during class change and in the lunchroom. I requested the faculty, staff, and students report any student disciplinary actions or threat to individuals or board property. He clearly took action. They don't even have a deliberate indifference claim here. But at most, they're trying to argue negligence by what they say their own expert said. He says that you're supposed to create policies. Well, the creation of policies, as noted in the Bathgate versus Mobile County Board of School Commissioners case, is purely discretionary. That is an immune function. Y'all reached the same conclusion in the ex parte Trotman case, where you said development of policies is an immune function. So the development, that's one of the things they said, that, well, each Birmingham school shall develop. That doesn't say Dr. Lyons. That doesn't say Dr. Herring. Then they say security measures. Well, the site of the policy 4.1 says that the superintendent and principals are authorized to take action. That does not direct them to take action. That is not a detailed rule, policy, or checklist that ruins immunity for somebody. Authorized access being restricted. Again, the superintendent, principal, and faculty administrators are authorized to regulate and restrict. So what's the conclusion the plaintiff's expert is? Defendant Lyons failed to provide leadership, supervision, and organization related to effectively and efficiently supervising his school. That's a discretionary function. And he's sued because he's the captain of the ship. So tell us back to that tragedy that happened in March 2007 in Enterprise High School. 8 children lost their lives when they were in the school when it was under an EF4 tornado. Is the principal or the principal and superintendent therefore liable because as captain of the ship, they should bear the responsibility? That's an entity liability argument, and they can't sue the entity, so they're trying to sue the individual. We don't allow that in other things. Pick any Alabama corporation. Bluebell Ice Cream, Listeria outbreak in Sylacauga. Are we going to sue the president of Bluebell because that happened? No, you sue the institution. Here they're trying to circumvent and they're trying to sue the institution. They're trying to not sue the institution, they're trying to sue the individuals. And so what that leads to is the nature of the claim is really a claim against the entity. And they're trying to bring it against the captain of the ship, that is Dr. Lyons, because he's there. Maybe the admiral of the fleet, because that's Dr. Herring and she's in charge of all of the schools. That's an unfair burden. And for that unfair burden to be placed on educators when we're having a hard time getting educators to begin with, tells us, as you said in the Nance versus Matthews case, that we cannot impose that obligation, that tort liability on them. You know how to prevent an accident like this? The kids come into school, they sit in their classroom. The teachers change. You bring their food to them. That way Michael Barber can't sneak out. They sit in a classroom the entire day. They don't move. Is that good pedagogy? Is that a good way to educate our students? Is that a good way to make Alabama better by having educated students come out of the school system? No, of course not. But that's what you said in the Nance versus Matthews case, that if we don't give them immunity, they will make decisions based on avoiding vexatious litigation and not what's wise public policy.
So the SROs are the police officers in the schools, is that right?
Yes, Your Honor.
Did you mention that there was a security office for the Board of Education? Tell me about that.
In fact, John Baker testified in this, yes, the director of that testified in this case. Those are non-APOS certified officers who provide security at school for the schools.
So there's an office within the Department of the Board of Education for Birmingham.
And they're armed, too.
Job it is to provide security.
Correct.
And do they also receive the feed from the security cameras?
They do. Yes, they do. So they have the ability to see all of that there. None of them are sued. The director of John Baker was actually deposed. So if we make everybody responsible because of the captain of the ship, I've represented Dr. Herring 5 times. I represented another superintendent 5 times. I've represented a principal in Birmingham 4 times. 2 of them came to this court. In each case, they were all successfully defended, and you found no liability. In fact, that's the problem with Alabama. What we have is a leadership. We have more lawsuits against individual educators than any other state combined. That's measured by the largest national teacher organization statistics. Sometimes there's more in Alabama than the next 2 highest states, because in other places they sue boards of education, and here they sue individual educators. Now, the track record is very good. There have been about 8 dozen of those cases that have come before you in the last 30 years. Educators have successfully avoided liability in all but a half dozen of them. That's how, mostly on the principle of immunity. That's how strong this immunity has to be, because think of it, if you were a young lawyer and you're sued for malpractice, you may get out of the profession. What about that teacher in the same situation? Yet we need those teachers to make sure that we have quality education and that we advance our state. With regard to the various things that they said in regard to the expert testimony, the expert testimony is nothing but legislative in nature. Let me address the things that they specifically said about expert testimony. The expert testimony with regard to, what did I do with my sheet? With regard to the claims against Trump. Trump said, had the defendants provided proper supervision and implementation of reasonable prevention and intervention strategies to create a safer and orderly school, it is more likely than not this would not have happened. Well, that is not a detailed rule or checklist. We still do not know exactly what was supposed to have been done. Were there supposed to be metal detectors at all 41 doors? Were there supposed to be people with wands going about? We had an ROTC colonel who's somebody you would think would recognize a military man recognizing a weapon, and he's the one who stopped the student from going into which the student ended up going not to where he was supposed to go for football practice, but he ended up, because the coach wasn't there that day, he went into French class. The second thing with regard to Trump, 5 years later, again, well, that is the second thing, we don't know exactly what was supposed to be done. At most, he proves negligence, but all the criticisms that he has are, again, the development of policies. And since the development of policies are an immune function, and they may not even be an obligation of the school, it's an obligation of the school, but not necessarily an obligation of the principal and the superintendent, then it's like legislative immunity, the same basis that you provide that. Once you're deciding how to conduct policy, the creation of policies is something that can always be criticized, but if you don't provide discretionary function, state agent immunity for that, then nobody will want to take the obligations, and they'll do the things like I suggested, keeping all the students in one classroom. And finally, we come up with these things occasionally. In a case where a student, mentally handicapped students, were left unattended, the affidavit from the student who was injured said, well, they're expert, I'll just read it to you, from BM versus Crosby. And what happened was the teacher left the classroom unattended. Mentally handicapped students, we don't call them mentally retarded anymore, but that's what it says. You wrote in BM versus Crosby, plaintiff's evidence is limited to the affidavit, and states they're expert. Leaving the children alone for any length of time fails to meet the expected standard of care for mentally retarded students, and is reasonably foreseeable that mentally retarded students left alone may do injury to others. That's BM versus Crosby, 581 at Southern 2nd at 843. The usefulness of this affidavit is at best questionable. Rule 56 of the rules requires opposing affidavits must be made on personal knowledge. Bare conclusory statements in an affidavit cannot be used in summary judgment proceedings. That's exactly what you have here. Bare conclusory allegations. They say that you failed to maintain safety. Well, what exactly does that mean? They don't get any more specific. And you concluded, actually Justice Houston concluded in that case, that shorn of their historic authority, often intimidated by unruly and violent elements, including their students, teachers in this state and country are under siege. To hold them under the specter of lawsuits leads to people getting out of education. For the 3 reasons I suggested, we ask that the petition be granted and that summary judgment be entered.
Thank you, Mr. Board. I want to thank counsel for their very helpful arguments. We will now be adjourned. The case will be submitted, and we will get a decision forthwith. Thank you very much.
All rise. The court is adjourned.